Good afternoon. My name is Hae-Sun Kim. Today, with the Labor Attorney Jung Bong-soo, we will discuss about the Labor Standard Act, Article 40, which is the prohibition of interference with employment. So, for the ordinary people, this particular article may be somewhat not easy to understand. So, could you define the terminology, please?
Yeah, okay. Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. This article 40 of the Labor Standard Act, which is the prohibition of interference with employment. That means no one shall prepare or the user the document that for the purpose of preventing or some interfering with the employment. So this is one of the most severe violation of the labor standard, like forced labor or violence at the work or interference with the employment. These are all most severe violations. So employer violate this article, they'll be punished with 3 years imprisonment, 5 years imprisonment, or the 30 million fine. So this is most severe violation. If employer or anyone who violate this article, like interference with employment.
I see. So it means, as you have explained, it means that no one can prevent the worker from getting a new job, or interfere the employee to get a new job. Yeah, this is for protecting the employee. But sometimes in a different environment, like very high-tech technology development companies who hire the workers, high-level workers, and he may have some very important secret.
Yeah.
And in case he move over to another company and also disclose some confidential information,
yeah,
it can also affect the company and the employer. So how can you explain about this?
Yeah, I think it's a really good question. Yeah, that is very opposite case. So this article, the prohibition of interference with employment, this is related to the freedom of occupation. So according to the Article 15 of the Constitution of Korea, everybody have freedom to choose their occupation. So, but however, the employees' perspective, they need to protect their intellectual property or their know-how related to the production or their skill. So that is ownership right. Also, this is a major the right of the employer or owner, according to the Article 15 or the Article 23. So, like Article 23 of the Constitution is related to the ownership right. It is absolute right. Also, Article 15 is freedom of the choosing their occupation. So no one shall prohibit they cannot prevent any such a behavior from involving with their job. So like employee, they can choose to work anywhere. So if employer involved in some interference with the employment, then it will be a severe violation of labor law. But what you said, just exception is property right. Like employer should keep their property right in order to maintain their business. So their rival companies, they always try to scout or attract very capable people out of their rival companies. So they propose more higher salary or higher position. So, but if employee choose to work for such a rival company cannot survive in this market. So in order to protect the property right, the employer may take some preventive action that is related to the protect of their secret, the trade secret. So there is always a conflict between freedom to choose their occupation or property right, intellectual property right. So there is always some conflict between two rights. But this article show employee has freedom to choose their occupation. Also, employee cannot prevent or cannot take such a negative measure to prevent workers from quitting their jobs. So this article shows the employee's right, or employee cannot violate this article. But at the same time, considering intellectual property, employer also have their own right to prevent their worker from quitting and joining rival company. Yeah.
I see. So, can you remember any case where the Gangnam labor law firm has advised any employee who left the previous job and tried to get new job, but the previous employer was interfering him from getting a new job?
Yeah, I think it's a really good question. There are many similar cases that I have advised to my client. But one of the typical cases was this is like orange or milk package company. So the sales director who know a lot of some business or their market or something, so he tried to quit and tried to move to the rival company. So HR manager asked me how to prevent him from quitting and joining rival company. So now he refused to, he almost quit, and so company cannot force him to work continuously for their company. So in that case, I made a written letter. So if the employee choose to work for rival company, then that is a violation of the company's the prevention of secret trade secret. So if employee transfer to such a rival company may take legal action against this action due to the revealing the trade secret to the third party. So at the time I made a preventive warning letter to this sales director, so he could not join the rival company. Yeah.
I see. Thank you very much for your comment.
Thank you for watching. Bye bye.